Do we have any requests for deferral of an application or request for a withdrawal of any applications? You not know of any, Brian? Okay, thank you. Adoption of the minutes. You all received the minutes?
I'll move the acceptance.
Moved by Dennis.
Were there amendments?
With the amendments, yeah.
Okay.
There was
The amendments?
Amendments, right?
Yeah, two amendments were made in section with respect to voting for vice chairman. It was indicated Jack as chairman, correction being Jack as vice chairman. And with respect to application E22, in the description with respect to the proposed severance, there's repetition of the words area of, so deletion of one of those two, one of that duplication.
Been moved by Dennis and by Rosemary. All in favor? Carried. Do we have any business arising out of the minutes? Any disclosure of pecuniary interest or general nature thereof? Correspondence, items for information. Do we have any correspondence or items for?
So there is a letter from Steve Clark, Minister of Municipal Affairs and Housing.
Business arising from the correspondence?
Sorry, can we back up, Mr. Chairman, and just receive and file that correspondence?
Yes. And
We'll need a mover and seconder for that.
I'll move.
And file.
moved by John Andrews, seconded by Doug Aldred. All in favor? It's carried. I'd now like to call on John Hogan, External Legal Counsel, to discuss the bill with us, the Bill 276, is it? Yes, Bill 276. Thank you, Mr. Hogan.
Morning.
Attending.
Thank you. So Brian asked me to attend today just to go through some of the changes that occurred when Act was passed on January 1st. In particular, as to changes applicable to the committee. In my research on it, I came across this document, which is prepared by Sidney Troyster, who's a lawyer in Toronto, who publishes a book called The Ontario Subdivision Control. He's in his fourth edition of that. He's prepared this summary in English so that people can understand it. So I thought rather than redoing the whole thing, we'll just take a look at Mr. Troyster's comments here, bring you up to date as to the effect of the changes, and we can discuss either why they were made or how they affect the committee. We won't go through the whole first part. He's just discussing that he's been at this for 22 years trying to get these changes made to the legislation because of the bureaucrats that relate within the act for lawyers and real estate agents and people who are dealing with land. So the initial bill had more changes. Not all of them were accepted, but the ones that were are set out here with a summary by him. So if we want to go through these down towards the bottom, item number 1, abutting properties no longer merge on the death of a joint tenant. Some of you would have been on the committee when the Campbells were doing their application, and this arose at that time. And this says that if routinely husband and wife own a farm or a house and they buy an adjoining property. And they properly put it in one of their names to keep it from merging with the farm or other home.
Right.
And that's all fine and good, but they put it in as joint tenant, so as soon as one person dies, the land automatically becomes owned by the surviving joint tenant and immediately merges without notice, without any documentation. It's just a matter of law, it immediately would merge. The change to the act now says this will not occur. The parties obviously intended to try and keep it separate. Historically, lawyers and conveyancers would routinely change the conveyances so that if it's a farm, for instance, you might have a farm corporation owning a 1% interest in one farm and the family members owning 99%, so they would never merge. But that didn't always occur, and we have circumstances where that has put people in the position of having to sever off the farm. And of course, that puts them into the regulations that say the farm has to be this size, it has to be no smaller than this, et cetera, which is distressing to these people who are always thought they could sell it at any time. So that's the first one listed there. So no longer will joint tenancy and the death of a joint tenant automatically merge the two properties. Yes.
Through you, Mr. Chair, was there any discussion about that rule being retroactive to someone that maybe had one done 6 months ago or a year?
Unfortunately, there's little guidance under the Act. And I don't know that any further guidance will be coming. So we look back to case law as to this particular act was not stated to be retroactive. Mr. Troyster's discussion on the matter is that his opinion is it is retroactive. And he's basing that on some case law and legislative interpretation. So was it the legislature's intent that this should be retroactive? His comments are, yes, it should be, and it was likely their intent that it would be, but they didn't say it. His final comment was, you got two lawyers dealing with a file, and one is saying there's a potential Planning Act violation here. And I say, well, that's wiped out by January 1st. Joint tenancy rules have changed. And I cite the case law that Mr. Troyster was talking about and the legislative authority interpretation, saying judges usually, if you're preventing an ill, we meant to do it forever. And then if that lawyer still has some question about it, the Planning Act allows two lawyers to look at the circumstance, and if they are satisfied that there's no harm in the Planning Act process, they can both sign the Planning Act boxes, and that puts an end to the question.
So in a real life example, if one was done, say again, 6 months ago or a year ago, deed was not physically transferred into a new name, it still hasn't changed.
Right.
And it should be just left alone. Should be.
Yes, if the lawyers interpret this legislation as I just discussed. Yes.
Thank you.
I ran across a circumstance where it wasn't exactly on point. It was to do with a trust holding. So a fellow had a property in trust for his daughter, and he had property in his own name next door. When they converted the property from the old registry system into the land title system, the rules are different from registry and land title system. And in the land title system, they don't recognize trusts. So it's not stated to be in trust for. So he went to sell one of those farms, and the lawyer objected, said, no, that's a Planning Act breach. We said, no, it isn't, it's in trust. My client said, well, if he doesn't want to buy it, he doesn't want to buy it. 3 months later, we sold it to another buyer, luckily for more money. And his lawyer agreed that, yes, this is this circumstance where the Land Titles Act is not in congruence with the Planning Act to the extent that I hold this in trust for my daughter. It's not mine. You sue me, you can't take that from me because it belongs to my daughter. But the other lawyer and I just signed the Planning Act boxes and the deal went through. I would apply the same method for dealing with retroactive situations where properties are currently theoretically held in one person's name upon the death of their spouse, because oftentimes they won't do anything. It just sits there until they try and sell the land. They say, well, where's Edith?
Yep.
Edith passed 10 years ago. Well, we would use this section together with the signing of the Planning Act boxes to get around that one. Any other questions on abutting properties and automatic joint severance merger?
Duke, you have a question?
So it does become merged now, but does anything have to be done to the landowners at any point to change it to a different name, or can it stay like that for?
Right now, the registry office would record it in John and Darnelia Hogan. It just sits there unless there's some notice that Darnelia has passed away. So when they either transfer it, or if they want to be proactive, they can transfer it yet to someone else. But I suspect my advice would be just leave it alone till you want to do something with it.
No, I just wondered if there was any timeline that something had to be done.
Nothing.
There is. Okay.
There's nothing, there's no guidance in the legislation. They're just saying that doesn't apply.
Okay. Thank
The
you.
question is whether it's after January 1st or going forward. And there's no guidelines for lawyers to say, well, do we put a statement in here someplace? The old act doesn't apply anymore, which is not normally what we do, because there's 300 years of old acts that don't apply anymore to transactions. So it will be a process between the lawyers and people who have an interest to see how we're actually going to implement this at the registry office.
Right.
Okay.
Number two, if there's no other questions about joint ownership. Number two, budding land that was the subject of consent, now considered a separate property. So this was a circumstance where you have property A and property B. And they're all one property now, but you severed A and you still own B. You severed it, it's still in your name. You're gonna sell that someday. Somebody comes along and wants to buy B. Severance of A has a stamp that says this property can be sold at any time, because Planning Act Committee has approved that as a lot that can be sold anytime. There's no such stamp on the retained land. So when a lawyer goes to buy the retained lands, he says, does the owner of this land own abutting lands? Yes. Then you got a Planning Act problem. You gotta get consent for B. And of course, the applicant says, are you out of your mind? I just spent $5,000 getting those two separated. Yes, but when you separated, you said this one was going to stay separate. So once again, lawyers would have to come in and say, okay, you want to sell B? That's fine. Take the title to A, transfer it to you and your wife for 1% interest, register that deed, sell B, and she gives you the deed back. Oh boy. So once again, there were workarounds for all these that lawyers would say, well, this is ridiculous, but I did one last week. Transferred property from a corporation to a corporation and one of the directors so we could sell the land next door. So that's how we worked around that one. This says that if consent is given and they request that the severed portion also be considered a lot for Planning Act purposes, then we won't have to do that anymore. You can actually sell B before A. So that's what that is about.
Thank God.
Questions on that one?
On to the next one.
next section doesn't come up very often, but it's long-term leases and parts of buildings. We don't run into it that often, but it allows more flexibility to give longer-term leases and parts of buildings leases. As I say, it doesn't involve us that often. Number 4, life leases involving part of a building or structure are exempt. Again, in our area, that would normally come up where I want to sell the farm to my son, but I want to stay in the house. So before, if I had a life lease, that life lease has to be over the whole farm property, not just the house, because I can't give a life lease that could go more than 21 years. So now the life lease can be just over the house and an acre, or whatever they decide upon. Otherwise, the life lease stays on the farm, and then my son Henry's trying to get a mortgage, and the mortgage company says, "Who's this guy?" "Oh, that's my dad." Well, the consent to the mortgage, is he going on the mortgage? Are we gonna put the mortgage ahead of his interest? And Dad may not wanna do that. So life estates would be allowed. Number 5, where land has been conveyed with this consent, it has a separate identity forever. That's once a severance, always a severance. So when the stamp gets put on the severance deed, there's various choices that planners have to put on there. One is, yes, we've consented to this. This lot is now created, can be transferred at any time, no stipulations. Or we can put the other stamp that says, yes, this is a severance, but it's basically a one-time severance. And any future transfers of these lands have to comply once again. The circumstance of that is where you would have, I convey a piece of property, I put a stamp on it, then I sell it to my neighbor comes back and says, "John, I just bought an F-150 and it won't fit in the driveway, I need another 5 feet." Severance application for the extra 5 feet. We would routinely have to go to the original owner, say, we have to ruin your deed where you got the ownership of that, because that can be transferred at any time. So theoretically, if we gave you the extra 5 feet, put a stamp on it, you could sell that without the 5 feet, and the Planning Act people would be saying, we didn't intend to create a separate lot. Those two have to merge. The only way we could make it merge is if the original lands were changed somehow, and they weren't the lands that were approved in the application originally. So Brian and I, or whoever, would decide where this 1 by 1 is coming off the original application to the county road or the municipal road to ruin the description. Once that description is ruined and the extra 5 feet comes in by conveyance, it merges. This allows us not to have to go through that process anymore. The applicant would say, I'm applying basically to ruin my previous severance to allow this to happen, which would be the extra piece. So again, it's something that lawyers and committees have been working around. It's cumbersome because the 1 foot has to be transferred. There's a mortgage on it. You have to get that discharged, et cetera, et cetera. Then you have to deal with this property and say, I don't want it. I don't want a 1 by 1. What's the insurance cost on that? How long do I have to hold it? So that's what we've been doing, is working around that, trying to explain it to other lawyers, to municipalities, and to people who are severing. I just want my driveway.
Yes.
Okay?
Yep.
So that's what that section helps with. So the owner whose land or part thereof, that's a subject of consent, can apply for a consent cancellation certificate. Cancel my previous rights to transfer that lot all by itself so I can get the extra feet on there. Okay? Any questions on that one? Saves us a lot of headaches. At times, transactions can be completed, have been completed that contravene the technical prohibitions. The owner of the house, and this is violation. So this is the validation section. So, as you're likely aware, there's mechanism to allow validation of title. So I buy a property, and the best example I can think of is I buy a property from Wilford 15 years ago. And there was some technical problem that gave rise to a breach in the Planning Act. So I want to get that corrected, but unfortunately Wilford has passed away. So he's no longer around to make an application. I can make an application as the landowner to have my title validated. The changes that are in here now, they're basically saying that they are making the validation process subject to the same rules as any other consent. Previous validation applications, depending on what committee you're dealing with or what granting authority you're dealing with, went the gamut from you just have to deal with the committee, you don't have to give notice to various other people or comply with anything else. We think what you're doing is within the purview of our decision-making, we're going to go ahead. This basically brings it back into conformance with all other types of severances so that validation, you are subject to the same rules as any other type of severance. Doesn't happen that often. Next one is very, very technical, deals with condominiums. If condominium owners, and you got a condominium and you happen to own the land next door, one of the owners, technically there's an owner of this land, an owner of that land. So they're just saying if in those strange, and it's usually developers, because I develop a condo here, but I still have an interest in this condo and I want to do another condo over here and sever it. And then they're saying, okay, for those purposes, it's exempt. I've never run across that, but there it is. Number 8, the housekeeping amendments, getting rid of old provisions. And they're talking about such as mortgage enforcement and eliminated ambiguous and inconsistent language over the many sections of Section 50. Technical amendments now permit purchasers and lenders and not just owners. So this is the problem that we had with surplus farm dwellers, where I'm a farmer, I own one house, it's on my farm, I've lived there all my life, as did my family. I want to sever the farm and sell it. I don't have a second house, I don't qualify. So the workaround was, as we had in our last meeting, was to sell all the land to an adjoining farmer, or if there's more than 50 acres, to any farmer, as long as that farmer would comply with the surplus. We transfer the whole property over to the new farmer. He then applies because he's the owner, because the access owners can apply. They then do the severance, then the new farmer transfers back to the house, to the original owner. And it's done. That again is cumbersome and dangerous for the original farmer. He's transferred everything he owns to the purchaser.
Right.
Yes.
And my first question is, do you know these people? You know, they seem like good people. They came from Toronto, and so it was another workaround that various committees were using. We've used it in the past here in Elton County in various degrees. Sometimes it would be the purchaser would bring in the deed showing that he bought the land from the farmer, and immediately, in other words, the committee would allow them to do it that way. You prove it. This now sets it up so that the agreement of purchase and sale can be between a purchaser who's a farmer who qualifies for certain controls. He makes the application. That would go hand in hand with an agreement of purchase and sale that says, I, John Hogan, am selling this farm to Brian Lima on condition that Brian will sever and sell 1 acre, 5 acres, whatever. Farmers don't like 1 acre, but so that goes hand in hand. We don't have to go through the sale of the whole property only to find out that there was some problem with finances or So that's one of the big changes that is helpful to us now, not just owners, but also purchasers can apply, and mortgage companies. Secondly, consent applications can be amended at any time up to a decision being rendered. So there's always something comes up. And the question is always, can I amend my application? I made the application myself. Then I went to see the lawyer 2 weeks before it was due, and he tells me this is the problem. So, and there's any number of possible reasons for an application to be amended. And the committee still has to say, well, are we going to allow that amendment before the decision is made? And the question there is how much notice and who gets it of that change in the application. If it's a minor change, shouldn't be a problem. But anyways, that is now there and available to the committee to allow an amendment up to a decision being made. And another big one is the time for satisfying condition is now 2 years instead of 1. So that people who, and more people are doing these applications themselves, and they get the decision from the Land Division Committee that says the decision is granted. Yeah. Don't say, don't read on to say conditional upon the zoning, take down the silo. Got that done. Till about 3 weeks before closing, and that's what about these conditions? Which led to a lot of people having to reapply from scratch. And I mean, the rules were there, it was quite obvious, but it just, people just didn't turn their minds to it, or in some cases, it took more than a year to actually get through the process. So now it's 2 years. Which is very helpful to people and everyone else. Any questions on those changes?
Do you have a
Is
question?
there gonna be any retroactive on that? Like, ones that have passed the 1 year? Is there gonna be anything to say that they're gonna be,
Same thing, no, there's no indication.
so it's January 1st on?
There's no indication that they're saying that the conditions, I would look to the decision itself, and if the decision itself says the deed will be here by September 22nd, 2022, then that's the decision. I don't think that section would be retroactive, because it's quite specific.
Yeah.
Yeah.
I didn't think it should be, but I thought.
I don't think it
They're
will.
probably gonna try and
For that
push it,
reason,
but.
Yeah, for that reason. I'm sure somebody's gonna be knocking at the door saying, I just found out I gotta do a rezoning.
I can probably almost give you one name right now.
Yeah. Jack?
However, along that line, there's nothing to stop that applicant where a decision has already been made with a cutoff date coming before the committee to ask for an extension, right? There's nothing to prevent that.
I don't believe there's anything that would prevent the committee from looking at it and determining whether in the circumstances an extension should be granted.
Okay.
But it would have to be some reason other than the fact that this has been changed, I would think, before we would deem an extension was.
I would think so. I would think so.
It'd have to
There's still a lot of decisions that have to be made by the committee as to the implementation of these rules.
Okay. Any further questions?
And the last comment is, with regard to these changes or timing, the committee and the secretary has to make a decision as to who gets notice of these changes and whose rights or interests are impacted by a change. I mean, I didn't object to the application. But now there's been a change that I would have objected to if, when I was at the meeting, I was made aware that that was going to be the case. So the committee and the secretary of the committee are going to have to be careful about who gets notice of any amendments or changes. Okay.
Yes. Any other questions of any member? No. Thank you very much, Mr. Hogan, John, I should say.
geared up and head out.
Guys.
Thank you.
Thank you very much. Any items under new business?
Can we receive the presentation from Mr. Hogan?
Pardon?
Can we have a mover and seconder to receive the presentation from Mr. Hogan?
I'll move it.
Moved by John Andrews,
Second.
second by Dennis, that we receive the report from John Hogan. Now, any new business?
We just need a vote.
Vote, sorry. All in favor? Carried. So. Now, any items for new business? Okay, none. We'll now go to the consent applications. And the first one is E522. Take notice an application has been made by Marilyn Ott, 706169 Township Road, RR2, Woodstock, for consent pursuant to Section 53 of the Planning Act as amended to sever lands municipally known as 9440 Graham Road, Municipality of West Elgin. The applicants propose to sever a parcel with a frontage of 21.86 meters, 71.72 feet along Graham Road by a depth of 68.67 meters, 225.30 feet, and an area of 0.15 hectares, 0.37 acres, to create a new residential lot. The applicants are retaining 1.07 hectares, 2.64 acres, proposed to remain in residential use. Are there any applicants or agents and interested parties who wish to speak to this application? Please introduce yourselves at this time.
Sure.
Hi, my name is Marilyn, and my husband Charles is here. And I just thought I'd introduce myself and say thank you very much for giving us this opportunity. And I also wish to thank the many people we've worked with. And so I don't want to name names, but Brian was one of them and other people. And thank you very much.
You're welcome. And now I'll ask Kevin to proceed, Kevin McClure, the planner, to proceed with the severance.
Thank you, Mr. Chair. As has been indicated, the application is proposing to sever off an existing residential dwelling and retain a portion of lands for future residential use, as you can see on the screen. The municipality of West Elgin did provide some comments. The planning staff's opinion is that the proposed lot creation by consent would appear to be consistent with the PPS. It conformed to the County of Elgin official plan. It conformed to the municipality's official plan. It complies with the zoning bylaw, subject to relief through a minor variance or zoning bylaw amendment. Right now, there's a deficient frontage as proposed through the severance, but the municipality suggests that it can be addressed through one of those two Planning Act application processes. Council recommends that the County of Elgin, that the consent be approved, and that subject to the lower tier and municipal conditions listed in the report, which I'll get to. County engineering, provided that the property is located on a county road. And then the Lower Thames Conservation Authority did provide that they had no concerns with the above noted application. So the recommendation is that the consent is consistent with both the 2020 PPS and complies with the County Elgin official plan regarding lot creation in a settlement area. As such, staff is of the opinion that the application is acceptable from a planning perspective. It recommends the approval of subject to the following conditions. So these are the county conditions. A digital copy of the draft and final deposited reference plan be provided to the County of Elgin. Solicitor undertaking to provide a copy of registered deed for the severed parcel once completed. Municipal addressing to be provided to Elgin County from the local municipality prior to final approval. To the satisfaction of Elgin County Planning. Direct connection to a legal outlet for the severed lot is required. If an existing connection is unavailable, to the satisfaction of the county engineer, all costs be borne by the owner. Discharge of water to the County of Elgin road allowance is prohibited. Number 5 of the conditions is that if necessary, an entrance permit be obtained from the county, Elgin County, for a new entrance to be severed or retained lands. All costs associated with this shall be borne by the owner, and a lot grading plan is required for the severed lot. Additionally, it is recommended that the following conditions from the municipality of West Elgin be included as conditions for consent. One, that the applicant meet all the requirements, financial or otherwise, of the municipality to the satisfaction and clearance of the municipality. Two, that the applicant provide a description of the lands to be severed which can be registered in the land registry office to the satisfaction and clearance of the municipality. Three, that the applicant solicitor provide an undertaking to the municipality to provide a copy of the registered deed for the severed parcel once the transaction has occurred to the municipality. Four, that the applicant shall make a payment of cash in lieu of applicable parkland dedication purposes subject to pursuant to section 51.1 of the Planning Act to the satisfaction and clearance of the municipality. Five, that the applicant successfully applied to the municipality for a minor variance or zoning bylaw amendment for this severed parcel of land, having such relief, rezoning of the zoning bylaw come into full force and effect pursuant to the Planning Act to the satisfaction and clearance of the municipality. Six, that the applicant have a drainage reapportionment completed pursuant to the Drainage Act to the satisfaction and clearance of the municipality. Seven, that the applicant shall have a septic system assessment be completed by a qualified individual on the proposed severed parcel to ensure that the existing privately owned and operated septic system is in working order and proper location, and complete any improvements necessary through a septic inspection to the satisfaction and clearance of the municipality. Eight, that the applicant shall have the septic system assessment be completed by a qualified individual and proposed retained parcel to ensure that the lands are suitable for the privately owned and operated septic system to the satisfaction and clearance of the municipality. Nine, that the applicant's solicitor provide a request for clearance of conditions to the municipality demonstrating how all the conditions of consent have been fulfilled to the satisfaction and clearance of the municipality. And 10, that the prior to the approval of the county, the county is advised in writing by the municipality how the above noted conditions have been satisfied. And finally, 11, that all conditions noted above shall be fulfilled within 2 years of the notice of a decision, so that the County of Elgin is authorized to issue a certificate of consent pursuant to section 53 sub 42 of the Planning Act.
Thank you, Kevin. Are there any comments from any of the committee members?
I'll move the motion.
It's moved by Dennis O'Grady, seconded by Rosemary Kennedy. Do the agents or applicants have anything to comment?
If we have questions about any of this, we can go back to Brian later as well.
Yes. Yes.
Okay.
Okay.
That's-
All in favor of the motion?
So the motion is to accept.
Yes.
Yep. All in favor.
John Selden,
Yes.
all in favor?
Are we supposed to go through every name or not?
No, we can see,
Okay.
and we heard
Okay.
confirmation from Mr. Selden.
The decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of the notice of decision in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 1 year to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Land Division at elgin.ca. A copy of the comment package is also available upon request, includes all correspondence received. Thank you.
Okay.
Okay, thank you very much. We appreciate that. Thank you.
Thank you very much.
Thank you.
Bye.
Next application is 2869362 Ontario Incorporated, 151 Rouen Street, Municipality of Central Elgin, in the community of Belmont. Is that right?
Yes.
Take notice that an application has been made by 2869362 Ontario Incorporated, care of Esther Reed, 18 Winfield Lane, London, Ontario, for consent pursuant to Section 53 of the Planning Act 1990, as amended to sever lands municipally known as 151 Rouen Street, Municipality of Central Elgin. The applicants propose to sever a parcel with a frontage of 19.78 meters, 64.90 feet along Rouen Street by a depth of 20.07 meters, 65.85 feet, and an area of 0.04 hectares, 0.10 acres to add to an abutting lot. The applicants are retaining 0.04 hectares, 0.10 acres, proposed to remain in residential use. Do we have any applicants or agents and interested parties who wish to speak to this application? Please introduce themselves at this time. Okay, I'll now call on Kevin to go through the application, please.
Thank you, Mr. Chair. Just by way of looking at the image on the screen, this will be, I guess, relevant for this application and the next application. Ultimately, is what's being proposed right now, through a legal interpretation of the existing lot. What the applicants are ultimately proposing to do is have two lots front onto Rouen Street. Historically, there's as part of the I guess the lot fabric as a historical plan of subdivision, they actually fronted onto the parcel of land to the west. So ultimately, what they're trying to do is it's two separate lot additions to reconfigure the parcel of land in order for it to front onto Rouen Street. So this application here for E622. There were comments provided by the municipality of Central Elgin that the chain link fence and hedgerow approaching onto Rouen Street and Lawrence Street municipal right of way be removed, and that frame sheds on the residential lot be removed to the satisfaction of the municipality of Central Elgin. That the applicant enters into an agreement with the municipality of Central Elgin to address the administrative, technical, and financial matters. The severed lands be merged in title with the abutting lands to the south, part lot 24, registered plan number 396. That subsection 3 or 5 of section 50 of the Planning Act RSO 1990 as amended shall apply to any subsequent conveyance or transaction involving the subject lands. The solicitor of the applicant is to provide an undertaking whereby they inform the committee in writing that the lands are being conveyed to an abutting property owner, and thus the merger of title will take place, which merger shall include all interests held in inclusive or mortgagee's interest, and that the municipality of Central Elgin be provided with a copy of the reference plan. County engineering didn't have any comments as it wasn't a county road, and the Kettle Creek Conservation Authority had no comments either. So as I guess the county's report provides, that the application is consistent with both the 2020 provincial policy statement and complies with the County of Elgin and municipality of Central Elgin's official plans regarding consents for lot adjustments. As such, planning staff are of the opinion that the application is supportable from a planning perspective and recommends approval subject to the following conditions from the Land Division Committee and its decision from the County of Elgin. The county conditions are that a digital copy of the draft and final deposit reference plan be provided to the County of Elgin. The severed land be merged in title with the abutting lot described as part of lot 24 and registered plan 396, and that a solicitor undertaking whereby they inform the committee in writing that the lands be conveyed to an abutting property owner, and thus merger and title will take place, which merger shall include all interests held inclusively of the mortgagee's interests. And then again, the Central Elgin comments were the ones that I provided, or conditions that I provided earlier.
Thank you, Kevin. Are any comments from any member of the committee?
Just a really
Dennis?
nitpicky thing, on the preliminary plan, survey plan, they've got it located in Middlesex County. Is that just a transcription error, or does the registry office not allow, it's probably an old historic thing, maybe at one point it was in Middlesex County?
No, excuse me. That one time, the community of Belmont was in part of it was in North Dorchester, Westminster Township, and Middlesex County. The other part was in South Dorchester and Yarmouth of Elgin County. I'm just making that comment because I was involved. I had property on both sides of the line.
However, can that just be changed to County of Elgin instead of County Middlesex?
I believe that it has to deal with that. That's the old historical land in the township.
So with all the, I thought the registry office, I thought with all the amalgamations, you could recognize the old historic municipality from way back, but I thought they allowed minor changes like that to recognize the new municipality that it's in, but the registry office doesn't allow that?
That would be more of a Land Titles Act sort of question that.
Just one thing to you, people still buying houses in those corners. Some go to the Middlesex County Registry Office and some go to the Elgin. It's always been that way.
Okay.
Just for information, Brian, and that's what happens in that area. And I think Kevin's right. It's just the way it is. It's been there for years and years.
Need to change it if that's the way it's always been.
Any other
Mr.
questions?
Chair?
Yes? Yes, John?
Yes, thank you, Mr. Chair, through you. Either to you or to Brian, I don't understand. Is there I found that actually confusing. Why are they reorienting the designation of these two properties? Is there a rationale behind that that's of importance to us, or is it just something they're doing?
Kevin will address that. John?
Yes, thank you, Mr. Chair, through you to committee member. The ultimately, as we've seen on the screen right now, there is existing dwelling and accessory structures on the property. The intent is for them to be able to sever off or reconfigure the property to allow for the severance and keeping those existing dwellings and structures, so that then they could, my understanding is to develop another residential dwelling that would front onto Ruin Street on that severed parcel. So in the absence of them being, having that reconfiguration, you'd have issues with side yard setbacks, rear yard setbacks for existing buildings, and I guess the detached garage that's currently on the retained parcel would actually be on a different property. So to address the current configuration of the building and structures on the overall parcel of land, this is the avenue that they've decided to go forward with.
Thank you very much for that. I just was not able to figure that out.
Okay. Any further questions?
I'll move the application.
Moved by Dennis O'Grady. Seconder John Andrews. All in favor? Carried. The decision rendered today for this application will be circulated within 15 days after the notice. There's a 20-day appeal period from the giving of the notice of decision, in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of the notice, the provisional consent becomes final. The applicant has 1 year to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Land Division at elgin.ca. A copy of the comment package is also available upon request and includes all correspondence received. Okay.
Question, Mr. Chair.
Yes.
Based on the blurb you just read, I think, do we not have to change that conditions must be met within 1 year to 2 years now? Based on the changes of Bill 276, every applicant now has 2 years.
So that's correct.
So you might want to change
Yeah.
that 1 into a 2 for future reference.
Okay, sorry about that.
That's fine.
Now we'll do application E722, which is the same, it's in Central Elgin. Take notice, an application has been made by 286-9362 Ontario Incorporated, care of Esther Reed, 18 Winfield Lane, London, Ontario. The applicants propose to sever a parcel with a frontage of 20.37 meters, 66.83 feet along Rouen Street by a depth of 20.14 meters, 66.08 feet, an area of 0.04 hectares, 0.10 acres to add to an abutting lot. The applicants are retaining 0.04 hectares, 0.10 acres, proposed to remain in residential use. And I don't believe we had any application. Do we have any applicants or agents wishing to speak to this? No, I'll ask Kevin to report on it, please.
Thank you, Mr. Chair. As was indicated in the previous application, this now is addressing the southern historical lot to then convey off and merge with the properties that were severed in the other lot, to the north, and then merged for the reconfiguration purposes. So there were public and agency comments from the municipality of Central Elgin. They're the conditions that I'll read shortly. Again, county engineer had no comments. It wasn't on a county road, and Kettle Creek Conservation Authority had no comments either. So similar to the previous application, the application for consent is consistent with both the 2020 provincial policy statement and complies with the County of Elgin and Municipality of Central Elgin official plans regarding consents for lot adjustments. As such, planning staff are of the opinion that the application is supportable from a planning perspective and recommends approval subject to the following conditions from the Land Division Committee in its decision from the County of Elgin. So the county conditions are that a digital copy of the draft and final deposit reference plan be provided to the County of Elgin. The severed land be merged and titled with the abutting lot described as part of lot 25 on registered plan 396. And that a solicitor undertaking whereby they inform the committee in writing that the lands are being conveyed to an abutting property owner, and thus a merger of title will take place, which merger shall include all interests held inclusive or mortgagee's interests. And then additionally, it is recommended that the following conditions from the municipality of Central Elgin be included as condition for consent: that a chain link fence and hedgerow encroaching on Rouen Street and Lorne Street municipal right-of-way be removed, and that the frame sheds on the residential building lot be removed to the satisfaction of the municipality of Central Elgin. The applicant enter into an agreement with the municipality of Central Elgin to address administrative, technical, and financial matters. The severed land be merged and titled with the abutting lands to the north, part lot 25, registered plan number 396. That subsection 3 or 5 of section 50 of the Planning Act as amended shall apply to any subsequent conveyance or transaction involving the subject lands. The solicitor for the applicant is to provide an undertaking whereby they inform the committee in writing that the lands are being conveyed to an abutting property owner, and thus a merger of title will take place, which merger shall include all interests held inclusive or mortgagee's interests, and that the municipality of Central Elgin be provided with a copy of the reference plan.
Thank you, Kevin. Any comments from any of the members? Moved by Dennis O'Grady, seconder by Doug Aldred. All in favor? It's carried. The decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of the notice of decision in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Land Division at elgin.ca. It's now 9, the next application was for 950, and it's that time or past. So the next application is 67-21. Take notice, an application is made by DeWild Farms Incorporated, 20183 Marsh Line, Rodney, Ontario, for consent pursuant to Section 53 of the Planning Act 1990, as amended, to sever lands municipally known as 20183 Marsh Line, Municipality of West Elgin. The applicants propose to sever a parcel with a frontage of 77.26 meters, 253.47 feet along Marsh Line by a depth of 89.48 meters, 293.57 feet, and an area of 0.69 hectares, 1.71 acres, containing one residence, barn, and shed, surplus to the needs of the purchasing farmer. The owners are retaining 13.2 hectares, 32.6 acres proposed to be added to the neighboring farm property to remain in agricultural use. Any applicants or agents and interested parties who wish to speak to this application, please introduce themselves to the committee now.
Yes, my name is Gary Merritt, and I'm a lawyer in Glencoe, Ontario, and I represent the applicant and John Lamb, who I would believe is in the room with you now.
Yes. Yes, he is. Thank you.
Thank you.
I'll now call on Kevin McClure, the planner, to discuss the application.
Thank you, Mr. Chair. This application was heard previously by the committee and was deferred. The reason for the deferral was due to, I guess, the nature of it being a purchaser of the property that was looking to sever off the parcel of land with the surplus farm severance. As was described or discussed by Mr. Hogan this morning, the changes in the Act through Bill 276 have now will now permit the purchaser of property to apply for the severance. As such, they're bringing the application back forward for the committee's consideration. So as part of the review and analysis, the municipality of West Elgin did recommend approval of the subject application, subject to the certain conditions that were provided that I'll go over in a moment. County engineering indicated that the application is not on a county road, and then the Lower Thames Valley Conservation Authority had no concerns. So the recommendation of the application is that was originally deferred to the committee at the time, as it was not considered consistent with either the 2020 provincial policy statement or the county official plan regarding lot creation for surplus dwellings in agricultural area, since the dwelling was surplus to the needs of the purchasing farmer, as was indicated. The changes in through Bill 276 that were in effect and in force on January 1st, 2020, and now allow purchasers under agreement of purchase and sale to apply for a consent, including a consent for surplus farm dwelling. Given these changes, staff are now of the opinion that the application can now be considered consistent with the PPS of the county official plan. So should the Land Division Committee support the application, the following conditions are recommended by Elgin County. One, digital copy of the draft and final deposit reference plan be provided to the County of Elgin. Two, solicitor undertaking to provide a copy of registered deed for the severed parcel once complete. And three, municipal addressing to be provided to Elgin County from the local municipality prior to final approval to the satisfaction of the county planning. And then Municipality of West Elgin recommends the following conditions be included as a part of the consent, if supported. That the applicant meet all the requirements, financial or otherwise, of the municipality to the satisfaction and appearance of the municipality. that the applicant provides a description of the lands to be severed, which can be registered in the land registry office to the satisfaction and clearance of the municipality. 3, that the applicant's solicitor provides an undertaking to the municipality to provide a copy of the registered deed for the severed parcel once the transaction has occurred to the municipality. 4, that the applicant successfully applied to the municipality for a zoning bylaw amendment for the severed parcel, and having such rezoning of the zoning bylaw come into full force and effect pursuant to the Planning Act to the satisfaction and clearance of the municipality. That the 5 being the applicant shall have private water and well assessment completed on the severed parcel to ensure drinking water source is safe for human consumption to the satisfaction and clearance of the municipality. 6, that the applicant have a septic assessment be completed by a qualified individual on the proposed separate parcel to ensure that the lands are suitable for a privately owned and operated septic system to the satisfaction and clearance of the municipality. 7, that the applicant have a drainage reapportionment completed pursuant to the Drainage Act to the satisfaction and clearance of the municipality. 8, that the applicant solicitor provide an undertaking to the municipality to provide a copy of the registered deed for the retained parcel prior to the transfer of the severed parcel by transferring retained lands to the purchasing farmer as part of a farm consolidation with the abutting farmlands to the west once the transaction has occurred to the municipality. 9, that prior to the final approval of the county is advised in writing that the municipality, how the above conditions have been satisfied. And 10, that all conditions noted above shall be fulfilled within here it's 1 year of the notice of decision, so that the county is authorized to issue the certificate of consent pursuant to section 5342 of the Planning Act.
Thank you, Kevin. Any questions from any of the committee members? Jack?
Through you, Mr. Chair, I'd like to note a few discrepancies that I see in this application, and maybe Gary Merritt can comment on some of them as we go through it. I'm looking at the amended application for consent, which was presented, and we've got the name of the owner listed as the Wild Farms, Inc. And then below it, 2C, we've got the name of the applicant, the Wild Farms, Inc. Now, based on the recent changes, Bill 276, allowing the applicant to apply for consent, I don't believe that the name of the owner should have been listed as the Wild Farms, Inc. in this case, because technically the sale hasn't gone through yet. So I think it makes it somewhat confusing, again, if the name of the owner was listed as the current owner, John Lamb, and the name of the applicant as DeWild, the applicant is definitely able to apply for a severance. Then below it, relationship to owner, purchasing farmer. If we go a little further down the amended application, number 15 shows to correct applicant to be called owner purchaser, and to correct the depth of the property that the committee would consider. That's good. I'm concerned with, I'm still scrolling down, authorization to appoint an agent. We, the undersigned, being the registered owner of the above lands, hereby authorize Adrian DeWild Farms, Inc. It's signed by the name of the owner, John Edward Lamb. So you see where I'm going with this causing confusion to me. I don't know if any other committee members feel the same way, but in one section of this amended application, we list an owner, and in another section, we list John Lamb as the owner. So just for future reference, and I should maybe point out that I am not in opposition to this application for consent to go through, but I think we need to address that the applications are completed properly. Scrolling down to page 14 of 17, surplus farm dwelling information. Number 3, to whom is the dwelling surplus? They've checked off owner. Technically, it's the purchasing farmer. So again, it's a discrepancy in the application that I think we need to address and keep in mind for future reference, that it does not cause us confusion down the road.
Any comments, Mr. Merritt?
Yes, it was done this way in discussion with Brian Lima, because your application forms, I was asked, and it made sense, that in paragraph 2 and throughout, I would call it owner/purchaser, because the person, once they put in an agreement of purchase or sale in, they're an equitable owner. So with your forms, it was decided the best way to describe everybody, because it was a surplus dwelling by the purchaser, was to call him owner/purchaser. So throughout the agreement, whenever I referred to DeWild Farms, I did owner/purchaser. I didn't say just owner, I said owner/purchaser. So basically, to an old lawyer back in the 70s, there were equitable owners and there was real owners. And it didn't seem to offend the concept of owner/purchaser. So whether the form will always be done like this, or whether the form will be amended for these type of severances by the applicants, I would say maybe the John Hogan would be consulted. Do people put them in as owner/purchaser, or? So that's why throughout I use owner/purchaser, because that was my discussion with Brian Lima.
Yeah, thank you very much, Gary. I'll now ask Brian Lima to.
Thank you, Mr. Chair. As Gary had indicated, I had a thorough conversation with the county's external legal counsel, Mr. Hogan. As a result of Bill 276, amendments to the county's application are needing to be made and will be made in the very near future to provide additional indication of, as Gary indicated, owner/purchaser. So the amended application as presented was reviewed by Mr. Hogan in thorough detail, and he's satisfied with the content of the description.
Yes, I think with this, what we heard from Mr. Hogan today too, will make it clear and we can get the forms changed, but we were caught in sort of a limbo situation there for a while.
I agree.
Could I just add one more comment?
Yes.
Just before Brian was privy to these meetings in person, back in September, when this original application came in, the previous application was the old way. We have since amended the application to include the name of the applicant, which was never there before. So we did make adjustments to the application already to conform with the fact that we knew that purchasers would be able to apply. I just think we've made it a lot more complicated than we needed to. I don't believe we need to have owner/purchaser. It's pretty clear. Correct me if I'm wrong, Mr. Merritt. It's just a technicality maybe, but I think it's one that warrants discussion. Correct me if I'm wrong. As of today's date, the name of the owner of this property is John Lamb. Correct?
The owner on the property, if you looked at the title, it is John Lamb.
Okay.
And it's whether you define owner as if John Hogan would say, yes, there are equitable owners and there are owners, so basically when somebody puts an agreement of purchase and sale in, they could be called an equitable owner, but I don't want to argue that.
Okay, I just wanted to make the point that if we look at the existing application that we have already amended, then number 2, name of owner should read John Lamb as of today's date. Number 2C, name of applicant, DeWild Farms Inc. And we can go forward with the applicant being the purchaser, and we don't have to make it any more confusing than that or complicated than that. The applicant has the right to make an application for consent, and away we go. I'm just thinking this is becoming far more complicated than it needs to be.
Well, I'd like to just leave, Brian will be meeting with John Hogan on this application. We've got a couple more yet out there that are gonna be the same way. They're all made well into last year, and this new bill has changed it. We've gotta get everything in. Well, I think we should, as chairman, I'd like to see John Hogan and Brian come up together and have the right form to fill it in the way that should be legally. The rest of the members have any comment?
Just a comment, I somewhat agree with the lawyer, because if there's a sale not gonna go through, he can't sever it.
That's right.
I think that's to kind of, a little bit what you're, I know it's confusing, but I think it's gotta be a sale to go through to make a severance, so I agree with Hogan, and what probably is, the way it's done is,
Yeah, it needs further clarification.
it's not right in their eyes, but I think it's right and legal.
Would, through you, Mr. Chair,
Yes?
would it be wise to have the chairman or chairman and vice chairman of the committee sit in on that discussion with Brian and Mr. Hogan for future revisions of the application that this committee has to deal with? Would it be wise to sit in on that discussion?
Well, I would like to, first of all, see them as chairman, I'd like to see them bring back the form from John Hogan on that, and then we can review it, because I say we've got other applications. Let them make it on the legal part of it, and Brian work with it, and then we'll review it at our next meeting if it's available, and proceed from there with comments. So all members have a copy, or all members see what's being discussed. So let's leave it at that, if everybody agrees on the committee.
Yep, I think that's fair.
Thank you. That's exactly why I would like it clarified going forward, because we're gonna have to deal with more of these.
Is there,
I'm moving.
moved by John Andrews, seconded by Doug Aldred. All in favor? It's carried. The decision rendered today for this application will be circulated within 15 days after the notice. There is a 20-day appeal period from the giving of the notice of decision in which any person or public body may appeal the decision or any condition imposed. If no appeal is received within 20 days of the giving of notice, the provisional consent becomes final. The applicant has 2 years to meet the conditions imposed and submit the necessary documents for certification, or the consent will lapse and a new application will be required. Please leave the identification signs in place until the appeal period ends, after which they can be removed. If you would like to be notified of today's decision, please request a copy by contacting Land Division at elgin.ca. Thank you very much, Mr. Merritt.
Well, thank you for your consideration.
Okay,
Thank you.
thank you very much. Our next, we have some new business to discuss. Julie, you have a few things to discuss
After the meeting, as we're.
after the meeting, okay? So no other new business? I'll ask, our next meeting is on March the 23rd. And I'll now ask for an adjournment. Moved by Dennis.
And my only comment is, I think John looks way too comfortable for this meeting. I'd like to see a bit more discomfort.
Believe me, I am not comfortable, honest.
All in favor of that? I think I asked that. All in favor? Yes.
No. Give me a second.
Chairman, we need someone to second that.
Oh, Doug second. Doug Aldred. Sorry. So we'll see you on March the 23rd then, John.
But stay on the line now.
Stay on the line though.
Okay, I will.